Well, federal judge Judge Boardman's not going to be happy with the new filing by the Trump administration about the removal and deportation of babies. And I'm not happy either, but I'm going to report on it right now. What is it with this administration? They just won't comply with federal court orders. And I've got yet another example in my hand. Here's what happened. Last Friday, on the last gasp, but I mean that literally, of the Supreme Court rulings, they dropped the one we were waiting on, the birthright citizenship context one, where they took away the Supreme Court 6-3 MAGA majority, the right for federal judges that they've had for decades to issue nationwide injunctions about things like constitutional violations that are nationwide in their injury, but federal judges now, except under very narrow, limited circumstances that the Supreme Court couldn't even put into writing, aren't going to have that ability anymore. So they sent all these three major cases about birthright citizenship back to the respective judges with instructions effectively by Kavanaugh and Sotomayor that if you're going to try to defend birthright citizenship and babies who were born since February 25th when Donald Trump's depraved executive order was issued all the way through now and in the future, if you're trying to protect them, get on your horse, file a class action lawsuit to define as the class all of the people that are who will be injured by the executive order being enforced, meaning the mothers and the babies and the rest. And that's exactly what several groups did, one up in New Hampshire and one in front of Judge Boardman in Maryland, in a case we call CASA Incorporated. And she held a hearing just yesterday. And during that hearing, she said, I am concerned about the babies, literally, and the babies being removed and deported, especially since I've set a briefing schedule about class action certification, because it's a process. There's a rule. Of course there is. Rule 23 of the Federal Rules of Civil Procedure that has to be complied with. The judge has to check the box on a number of elements. There has to be briefing about it. You know the Trump administration is going to oppose it. So she set a briefing schedule and a hearing for the 27th of July. But she's worried that between now and the 27th of July, the Trump administration is going to start removing and deporting babies. And she wanted the lawyer, Brad Rosenberg, to tell her straight to her face whether they were going to do that. And he said no. But no federal judge, no, I'm going to put this out there. No federal judge can trust anything that Donald Trump, his administration, Department of Justice says in their courtroom. There is just no credibility, not a shred left of the Department of Justice, not with Pam Bondi as the head, not with Donald Trump calling the shots and being the puppet master, not with people like Emil Bovee, the number 3 in the Department of Justice, who got caught in a whistleblower letter, who got caught during a meeting telling all the lawyers for the immigration unit to lie to federal judges, don't comply with their orders, and tell them to go fuck off. Pardon me. His language, not mine. So, you'll have to excuse Judge Boardman if she doesn't believe the oral pronouncement of Mr. Rosenberg in her courtroom. Other judges have been lied to. According to the whistleblower, Drew Ensign, who I haven't seen in the last few court appearances, lied to Judge Zinnes, lied to Judge Boasberg in related matters about removal and deportation. So why would she believe him? So she ordered by today, and I have it, that the government tell her their position about whether they're going to be deporting behind her back while she's still ruling on the class action, or she's going to remain in place. She wanted to know particularly whether they're going to exercise their right, since there's no right now there's no proper injunction in place because the Supreme Court ripped it away and said the judges need to reevaluate the scope of the injunctions they already entered, basically staying those injunctions, and also they have. So right now we're in that twilight, the twilight period, purgatory for these babies being born about enforcement. So she said, give me the order. Give me your written position as to whether you are or you're not. Now, that would have been a simple document. It would have taken the form of something like, we will agree not to remove and deport babies during the interstitial period between now and the court's ruling on class action certification and the pending motion for temporary injunction. There it is. I just wrote it. It's 2 lines. That's not what they said. Here's what they said, and I'll read it. Pursuant to this court's order, this is from yesterday, directing the defendants to submit in writing by noon on Tuesday, July 1, their position on what actions the United States may and may not take pursuant to the executive order between now and July 27th, defendants submit as follows. Here's the spot where they're supposed to be comforting to the judge. We will not deport babies. That's not what they write. On June 27th, the Supreme Court granted the following partial stay of this court's preliminary injunction. And then they quote from the Supreme Court on Friday's decision, right? It didn't take long. It was only 1 paragraph about the government's application to partially stay the preliminary injunctions are granted, but only to the extent that the injunctions are broader than necessary to provide complete relief. So there is an argument. There is an argument that there is an injunction in place. It's just been pared back. Next paragraph from the Trump administration, signed by Brad Rosenberg. Under the Supreme Court's stay, July 27th, 2025, which is the date the judge is holding a hearing and briefing about whether she's going to certify the class, is the earliest date on which defendants may begin to apply to Executive Order 14160 to persons covered by the order. I'm still not comforted, are you? However, the executive order also provides for a 30-day ramp-up period. The court's stay thus allows defendants to immediately begin to develop and issue public guidance about the executive plan to implement. You could read that as they need 30 more days after the 27th in order to implement. But I don't see that because the 30-day ramp-up period could be going on right now. So I don't think this is comforting at all to the judge. I think she calls the parties back in and says, listen, I don't know why this is so confusing. I asked you to tell me whether you are or you are not going to deport people, babies, between now and the 27th of July. And instead, I got a bunch of gobbledygook. I got a bunch of, quote, cut and paste from the Supreme Court and then telling me about a 30-day ramp-up period and the earliest date that you can start removing. That doesn't give me any comfort if I were the federal judge, Judge Boardman. Why does she care? Because she is going to speed up her use of her equitable inherent authority. She will speed up and enter a temporary restraining order and a preliminary injunction and certify the class faster based on this nonsense filed by the Trump administration. Because you can't trust them. Sounds like they think the earliest they can start removing is the 27th of July. I don't know if she's going to have everything resolved by the 27th of July. If I were her, in a prophylactic measure, I would enter a temporary restraining order right now. On the class, I'd provisionally certify the class, add a temporary restraining order to it to make sure no babies are removed from now until the judge has time to do her final decision on class action and enters a preliminary or permanent injunction. That's what she has to do. We'll follow it right here. You're on MeidasTouch. Hit the free subscribe button. That's the sound of sliding over to Legal AF, the YouTube channel. Hit the subscribe button there as well. Legal AF, the podcast, Wednesdays and Saturdays at 8 p.m. Eastern time here on the MeidasTouch Network. Baby's got a brand new pair of shoes, and Baby's got a brand new podcast. It's on Tuesdays here on the MeidasTouch Network. We call it The Intersection with Michael Popok. Join me 8 p.m. Eastern time on Tuesdays on the MeidasTouch Network and on all things Legal AF. So until my next report, I'm Michael Popok.
Hey everybody, Ben Meiselas here from the MeidasTouch Network. I wanted to let you know about my podcast partner, Michael Popok's new law firm. It's called the Popok Firm. Michael Popok's pursuing his dream of starting his own law firm, really based on the popular demand by all the Meidas Mighty and Legal AFers who were approaching Michael Popok with their cases and saying, can you help us? And at that time, Popok was not able to. So he went out on his own. He started the Popok Firm, where he is now handling catastrophic injury cases like car car accident cases, trucking cases, malpractice cases, big negligence cases, wrongful death cases. So if you or someone you know have a case like this, the consultation with Popok's firm is free. Give him a call. See if you have a case. It's thepopokfirm.com, thepopokfirm.com, or you can call 877-POPOK-AF, POPOK-AF. So 1-877-POPOK-AF. Give Michael Popok a call. And I'm really proud of you, Popok. Thanks for all the hard work you're putting in.